Hello everyone, welcome to the GeoEcolologist. I am Dr. Krishnanand and you have been watching my series on oceanography. So in this session on oceanography, we are going to learn about something very interesting and important, that is law of the sea. So the concept of territorial waters, various laws in terms of the international law of sea and also certain definitions. So before we go ahead, don't forget to subscribe to our channel and also do share the videos with others as well. So now let's understand the law of the sea. Before we go into the details of international law of the sea, there are two important things that we must understand. One is something called maritime law and one is the international rule or the international law of the sea. So what is the difference? Now remember, maritime law, which is also known as admiralty law. This is basically what? A body of laws, conventions and treaties that govern the private maritime businesses. That is one important point with maritime law to remember, that it is talking about private maritime businesses and other nautical matters such as what? Shipping or offences occurring during this particular business. So that is regarding the maritime law. But international rules which govern the sovereignty of the nations and in accordance to the international community, that is basically in terms of the oceans and seas limits, that is basically called the law of the sea. So now let's elaborate further about the historical aspects, how these laws of the sea came to being and how in the present scenario it is understood. So let's elaborate furthermore. So going into the historical perspective, as we have already also learned in the evolution of geographical thought in previous lectures, that the Western or Northwestern Europe and Mediterranean was where the maximum sea voyages and inland trading, and apart from that the exchange was happening through sea routes or through inland sea routes. So what happened? Historically, if we look, the Byzantine Empire had the first kind of legal codes called Lex Rhodia that we observe, which was between 6th and 8th century Common Era, that is about 1200 years ago, right? And it was used for the purpose of governing the trade and navigation basically in Mediterranean, which is supposed to be the first kind of legal codes for the sea. So this is where we are coming from in terms of the international law of the sea. So earlier they were basically maritime law codes. They were not international treaties, right? So from maritime law codes, basically which are known in the Middle Ages by the names of Rolls of Oleron, which drew from the earlier Lex Rhodia, and also the laws of Visby. Now what is this law of Visby if you're confused? Remember, it is basically about the accountability of whom? Of the sailors by the masters. So if I am a sailor, I am going to sea and I fell sick, or if I die, who is going to pay for it or who is going to be accountable? So that was being governed by this law of Visby, that the masters will have to pay if the sailors have sickness or if they die during the voyages. So this was the first kind of its mercantile city-states law. And remember, the city-states league, which was the combination of all the mercantile class of merchant guilds that we say during the northwestern and central European reign of Middle Ages, it was called Hanseatic League. So the Hanseatic League was first of its kind, that was of commercial and defensive confederation of the merchant guilds that existed in the Middle Ages, that is where in the northwestern Europe, as you can see in this map. So this was the period where most of these maritime laws were into the action, from where we picked up into the international public law of the sea only in 17th century Europe. And it was why? Because of the unprecedented growth in the navigation sector. Remember, the world was being polarized because Portugal, Spain, British, all of them were at sea, and many times they were also at the sea and they were at the war in the sea. So that was an important point to remember here, that because of this, that there was a need for international treaty or international law. Apart from that, there is one more point to remember, that Spain considered Pacific Ocean, which is called Mare Clausum, as the closed sea off limits to the other naval powers, in part to protect its positions in Asia. So that was one point where you have this territorialization happening, exertion of power happening in the sea. So that is where we are coming from in terms of historical perspective. Now if we look into this Mare Liberum, which was first of its kind, the first volume of book which was produced by Hugo Grotius. And who was Hugo Grotius? He was one of the first international Dutch jurist or philosopher who considered as father of international law. So remember, the Hugo Grotius is also known as father of international law in general connotation for his Mare Liberum, the Freedom of the Seas book, which was published in 1609. And what was there in the book? It said basically was that every nation is free to travel and every nation has equal right in the sea. That is trading rights, traveling rights. So this was important point that was raised for the first time by this Dutch jurist. And Grotius also observed what? He observed that unlike land, not like it is on the land, sea has something which is different. So on which sovereigns could demarcate their jurisdiction, sea was akin to like air, like a common property to all. So this common property nature of the sea was first time being discussed by Hugo Grotius, and that's why he's also known as father of international law as early as 1609 when he published the Freedom of the Seas, this volume. If we look into the further journey, what we see in 20th century, as many nations expressed their desire to extend their territorial limits, their sovereign limits on the sea, that was part of the national maritime claims that they made. So this was because they wanted to exploit the mineral resources, fishing, and further what also led to the enforced pollution as well on the seas. So this was the situation in 20th century, and we find in 1930 the League of Nations called for conference at Hague, but without any significant agreement or result. So that was a problem. Then further, if we observe that 20th centuries was the time when technological improvements in fishing, oil exploration, mineral exploration happened, and most of the developed countries that we see today were actually looking forward to expand their sovereignty into the sea as well. So in 1945, the US President Truman, in his very famous doctrine on the territorial waters, said that the US had all the rights to proclaim the international principle of nations' right that was supposed to be on its natural resources on the adjoining areas of United States. So that is when this debate started or sparked after 1945. And then quickly it was followed by the other countries like Chile, Peru, Ecuador, because they also wanted their rights up to almost 200 nautical miles to cover the Humboldt current fishing grounds that is part of the Southern America. So that was between 1946 and 1950, and this was the time in 1950s when the first international attempt to actually codify or promulgate first kind of a comprehensive law of the sea was actually taken into consideration. So when was the first attempt on this lawmaking? It was in 1956 when United Nations held its first conference on law of the sea, which is called UNCLOS 1, because further ahead, as we see, there were more UNCLOS meetings held. So first one was held in Geneva in Switzerland, and it resulted in 4 treaties that concluded in 1958. So now further, let's elaborate and see how it came to being and how it developed as law of the sea further more. So now the next important point to discuss is what was the need basically. So if we summarize the need, what you observe that there was a situation in 20th century, by mid 20th century, that most of the nations were extending their national claims over the offshore resources. So what happened? There was a growing concern over the toll taken on coastal fishing, because lots of exploitation was happening and a threat of pollution and waste also started to come into the picture. So this was the time when there was this need established that now there must be some kind of a particular protocol that should be signed by the countries to follow. Otherwise, this will be a reckless exploitation. So the hazard of pollution was ever present, and also the navies of maritime powers were competing to maintain their presence across the globe. So this was also happening at the same time. And remember, this was also the time when from 50s to 70s, the era was almost of this Cold War. So also that was another important point here. And apart from this, the claims were tangling, spreading pollution, and growing tension between coastal nations was one of the major reasons that UNCLOS, the first important conference that we talk about, had to happen. And remember all these important points. For example, if you observe the prospects of rich harvest of resources on the seafloor, the increased presence of maritime powers, and also remember the pressures of long distance navigation, which were seemingly outdated, and These were the major reasons that all these were threatening to transform the oceans into another new arena of conflict and instability. So because of all these reasons, there was a pertinent need to actually make a proper international law of sea. So after the first UNCLOS, the second United Nations Conference on Law of Sea, that is UNCLOS, which was held in Geneva in 1960, first was in 56 that we saw. So what happened? But it also could not be productive as no concrete agreement was signed. But the third UN Conference on Law of the Sea was held in 73 to 82, and remember, finally the Law of the Sea Treaty was agreed upon by majority of nations in year 1982. So it took almost 30 years, or to say 35 years, right from 1945 to actually finally make this kind of law of the sea treaty by majority of the nations. While also, if you observe, 17 nations were absenting from the voting, and remember, United States, Turkey, Israel, Venezuela voted against the treaty. That is also very interesting because they had their own claims on the sea which was not mentioned on this particular treaty, so they refused to sign. So that was also important here. Now, the Treaty of Law of the Sea was ratified by required number of nations finally in year 1993 only. So it took almost another 11 years to finally comprehend it into the Law of the Sea Treaty as an international law. That is the entire journey we have seen. So the following are the basic components that you can observe on your screen, part of the Law of Sea Treaty. So if you read it, jurisdiction of coastal nations, that include territorial sea and also EEZ, this was clearly demarcated. Then ship passage, free passage of ships of all nations of high seas within territorial sea for interaction and also for navigation. Then third important point in this treaty was extraction of minerals from deep ocean. So it was clearly written in terms of the treaty that control of exploitation of mineral resources of the deep seabeds by private companies under the regulation of International Seabed Authority ISA of UNO was permitted. Then there was also about that if there is a dispute, how will this dispute be resolved? So arbitration of dispute was another clause that was part of Law of the Sea Treaty here, and it was to be under United Nations Law of the Sea Tribunal. So there was a tribunal which was set up under which all those arbitrations were discussed and it was resolved. So that was the provision that we see. So if we take a summary of this UN clause that we say United Nations Law of the Sea Convention, what we observe, the UN's groundbreaking work is adopted in 82 and it was ratified in 93 that we already discussed, and the convention actually resolved several important issues related to the usage of ocean and also the sovereignty of the nations related to the territorial waters. So what you observe in the points here, established freedom of navigation rights, set territorial sea boundaries, that is about 12 miles offshore, then set exclusive economic zones limit up to 200 miles offshore, then set rules for extending continental shelf rights up to 350 miles, created ISA, that was important authority, remember, and conflict resolution mechanisms under UN were actually set up. So these are the summary if you say at UN Clause 1982, which was ratified in 1993 in one particular document. Now if you observe marine zones, and what you say, the definition according to this of the marine zones have been divided in different particular ways. So if you observe this, they have been divided into different zones on the basis of their purposes. For example, what are the purposes to divide these marine zones? One is the sovereignty of the nations, exploitation of the marine resources, trade and transport, recreation, and war practices. So these are the important 5 points according to which the marine zones have been delineated, and according to the number of international laws, they were also enacted in terms of legal recognition. Now, the offshore areas of a country have been divided into 3 major zones. If you observe, one is territorial sea, one is EEZ, that is exclusive economic zone, and third is the high sea. So what is this exclusive economic zone? This particular area, if you observe EEZ, then you have a high sea, that is offshore, and then you have a territorial sea, and there is a contiguous zone as well. So territorial sea, if you observe, it is about 12 nautical miles, that is clearly mentioned here, and EEZ is supposed to be 200 nautical miles. So that's important here. Now, one by one, let's discuss territorial sea and other parts of the sea as well. So if you observe the first one, territorial sea definition, the seaward water from the coastal land of a nation is called territorial sea, the seaward extension. So this point is important. And what is the limit? 12 nautical miles towards the sea. And in the beginning, the seaward limit was not 12 miles. It was set to almost 3 miles, but later on it was increased. Now, if you go to the limit of territorial sea for different nations determined differently, for example, if you observe, Latin American countries have determined their limit of territorial sea as 320 kilometers, that is 200 miles, while USA accepts 4.8 kilometers, that is 3 miles as the seaward limit of the territorial sea. So there is also a little difference with different countries. So if you observe, territorial sea has been variously named as marine belt or marginal sea as well. So territorial sea can also be called marine belt or marginal sea. Apart from this, the coastal nation has the right of sovereignty over its territorial sea. That's important. And no other country can enter the territorial sea of a country without the permission of that particular sovereign nation. That is important point to remember in territorial sea. Then talking about the next one, that is exclusive economic zone, that is EEZ. Remember, EEZ extends up to 200 nautical miles from the baseline, and 1 nautical mile is 1.852 kilometer. So that is important to remember. And the concerned coastal state has an exclusive right on what in EEZ? They can do survey, they can exploit the reserves, then conservation and management of mineral resources can be taken up in this particular area. And also remember, in EEZ, one important point is also there, that no other country can venture in any economic activity, for example fishing or deep sea mining in this particular zone, without the permission of the concerned state. That is also important. But this zone is open for laying down submarine cables, navigation of ships, and flying of aeroplanes for other states. So that is difference between a territorial sea and an EEZ. So in EEZ, other countries can lay down their submarine cables, navigation can happen, aeroplanes can fly, but economic activity cannot take place. That's why it is exclusive economic zone. That is one point to remember here. And the third one, which we know is by the name of high sea, which is away from EEZ. So high sea extends beyond the seaward limit from EEZ, and remember, all the countries have equal rights, and it is also called international waters. Remember this concept of international waters, because it is like a common property resource. So high sea is supposed to be for everyone. People can navigate, take on fishing, mining, and other activities as well. They can lay down explorations and scientific researches in international water. So there is that kind of common property resource kind of concept. And remember, nearly 50% of the planet's surface area is covered still by high sea. It means 50% of the surface area of the ocean is still under international waters. So that is an important point to remember. Apart from this, there is something called a polar code. Now, what is this polar code? In 2017, the International Code for Ships Operating in Polar Waters, this was entered into the force. Now, the polar code covers the full range of design, construction, equipment, operational training. Apart from that, environmental protection matters are being taken up relevant to ships operating in inhospitable waters surrounding the two poles, that is North Pole and South Pole. So this polar code has been mentioned, and now it is into the force from 2017. Now, why was it important? It was important regulatory development in the field of transport and trade facilitation around the polar areas, which has a range of regulatory developments related to maritime as well as the chain security and environmental issues. That is important to remember as the polar code. So if you observe here, there is a color coding. The green color represents full national jurisdiction and sovereignty. So what are the green colors? Look, national airspace, land territory surface, internal waters, territorial waters, right? Land and territory underground, continental shelf underground. These are the green zones in the sea, right? Where a nation has full jurisdiction. Then comes the yellow zone. What is this yellow zone of the sea? Where you have restrictions on national jurisdiction and sovereignty. For example, territorial water airspace, contiguous air zone, contiguous zonal surface, EEZ that we say, exclusive economic zone surface, continental shelf surface, and extended continental shelf, as well as the underground area. So these are the exclusive ones, that is yellow ones, that is restriction. And the international jurisdiction per common heritage of mankind is this pink zone if you observe. So outer space includes Earth orbits, Moon and celestial bodies. International space, international water surface, where you have this international waters that is also called high sea. So this particular zone if you observe is what we are looking into the law of the sea. So what you observe that it is about all the space, but from this if you want to take down only the ocean part, so what is this? Internal waters and territorial waters are full national jurisdiction part. EEZ is kind of a mixed, right? And international waters, that is high sea, is a common resource for the mankind. So that is important to remember in terms of the national jurisdiction and sovereignty given in this particular diagram. So now, when we have learnt in details about the law of the sea, in the sessions to come, we'll be talking more on oceanography and other related topics. So stay tuned, stay safe, keep watching.